Good afternoon, and thank you so much for being with us this afternoon. Before we begin, I want to give you just a little bit of housekeeping. This webinar is being recorded. We will be sending out the link to the recording right after the webinar, so keep a lookout for that one. We will remind you to keep yourself muted. We will mute you actually during the presentation. Feel free to use the chat box for any questions that you have as they're presenting. After the presentations are completed, we will be having a Q&A section, and Tracy is going to be reading off your questions to our panel for answers. So again, thank you for being here. I'm Liliana Negrelli. I'm with Churchill Mortgage. I've been here in the industry since 1985, not for 85 years.
Good girl.
It feels
You
like
look
it.
great.
You look great.
I've been with Churchill for the past 12 years. I've seen a tremendous amount of changes in our industry since that time, and this NAR settlement is one of those huge changes. Joining me today are Mitch Keider. He's the chairman and managing partner of Wiener Brodsky Keider. It's a national law firm that specializes in representation of financial institutions, residential home builders, and real estate settlement service providers. Mitch represents banks, mortgage companies, home builders, credit card issuers, and other financial service companies in a broad range of litigation and regulatory and compliance matters. He defends clients in investigations and enforcement actions before the CFPB, HUD, VA, FTC, Fannie, Freddie, Ginnie Mae, and various state, local regulatory agencies and attorney generals. Mitch is a fellow of the American College of Consumer Financial Services Lawyers. In addition, Mitch acts as a general counsel for companies like Churchill. We use Mitch often, and litigation counsel for Fortune 500 companies. Glad to have you, Mitch. Christy Wilson is the president and CEO of the Wilson Group Real Estate Services, a full-service boutique real estate firm with 90-plus agents, specializing in residential and commercial sales and offering a full-service property management division. As a real estate broker and owner, she's been heavily involved with the Greater Nashville Realtors for the past 28 years, serving in almost every capacity at the local level, including committee chair, board members, and president of the then GNAR. She's also been heavily involved in the Tennessee Association of Realtors and at the national level with the National Association of Realtors. She's a past recipient of the Realtor of the Year for GNAR and Realtor of the Year from the Tennessee Association of Realtors. Thank you for being here. And we also have Kevin Watson, our very own regional manager for Middle Tennessee area for Churchill Mortgage. He's been a home loan specialist and licensed in 10 states for the past 30 years. Kevin is the Churchill Chairman's Club member, and we're so excited to have him be included on the panel.
Thank you.
So the topic we're going to be discussing today is the National Association Realtors recently settled class action litigation. And it's related to the requirements of how buyer and seller agents are being compensated in connection with home sales. The NAR has agreed to a new number of changes in how realtor compensation works and the MLS and how it will be operated. Settlement process is still ongoing, but it could have far-reaching implications on the home sale process. It's important for participants in the residential real estate business to keep abreast of these changes and know how it can impact their business. So I'm going to turn it over to Mitch, who can talk to us about the legal side of it, how this settlement happened, what's actually contained in the settlement, and then we'll switch over to Christy, who will talk to us about the implications as she's seen in the negotiations between buyers and sellers, and maybe even touch on any changes in the MLS itself.
Sure.
Mitch, thank you very much. I'm going to turn it over to you.
All right. Well, thank you for your introduction, Liliana, and thank you all for joining us here today. As Liliana has said, there are some rather significant changes that are coming to your industry as a result of the NAR lawsuit and its settlements. And so we're going to talk a little bit about how that came about, what happened in that particular lawsuit, and what the new changes are and what the implications are. So let's go ahead and just jump right into it. So NAR, the National Association of Realtors, your trade association in Washington, D.C., is actually the largest trade association in the United States. And for many, many years, it's been the most powerful trade association in the United States. But several years back, actually going back about 5 years now, there have been a number of antitrust cases that were filed naming the National Association of Realtors. And these cases regarded real estate agent compensation practices and the interplay between NAR and how members were getting compensated. The main case, for lack of a better term, the case that is most significant today is a case that was brought in federal court in Missouri. Its name was Sitzer Burnett v. NAR. It was originally filed back in 2019, and the defendants were NAR and 4 large real estate brokerage companies. It was a class action lawsuit, and there was a fight over whether or not it could be a class action lawsuit, but ultimately a class was in fact granted in 2022. And the case did go to trial in 2023. So what's this all about? It's about co-brokerage arrangements and the NAR participation rule. NAR and its state and local affiliates own and operate most multiple listing services, MLSs. And you as realtors understand that access to the MLS has always been conditioned on agreeing to follow NAR's rules. Members of an MLS must list all of their properties on that particular system. NAR, years ago, promulgated what is known as a participation rule. It's a co-brokerage compensation rule. And what it did was it required sellers' agents who used their MLSs to set a mandatory commission for buyers' agents. So on the MLS listing itself, which is obviously very important to everyone that is here on this online today, you would list what the broker fee would be and what the buyer agent fee would be as well. The commission, as I said, be displayed on the MLS when the property is first listed. And, from that point on, it's really effectively really not negotiable. So the allegations by the plaintiffs in this particular case, and I might add that, in previous investigations by the DOJ, they had similar type allegations. And that is that this participation rule, that what NAR has dictated be done on their MLSs by having a seller agent commit to what the buyer agent's compensation is going to be. Well, the allegations are that that violates antitrust laws and it violates the Sherman Act. The allegations went along these particular lines. The plaintiffs in our case said that this particular rule drove up the commission rates across the board. We know that typically your commission rates are 6%, and there's a 3% split that you put on the MLS that goes to the agent themselves. And the allegation is that NAR effectively mandated those particular amounts and prohibited competition from occurring as to what the proper commission would otherwise be. And one of the issues that were raised in this particular lawsuit was the allegation that buyer agents are not going to show homes that list a lower commission rate on the MLS. And therefore, the conclusion that was drawn by the court and by the jury in this particular case was that kept those rates artificially high. The lawsuit also claimed that real estate agencies like this rule because it kept those commissions high, and buyer agents got paid. Potentially, sometimes they worked hard and sometimes for very limited work. The other issue that concerned the plaintiffs in this case is that realtors, real estate agents that did not follow the rules effectively were punished by NAR. There was enforcement by NAR, and you could in fact get kicked off the MLS for doing that. So what happened in the particular case? 2 of the 4 brokerage companies settled before the trial ever occurred. And combined, they settled for $138.5 million. As for the other 2 real estate brokerage companies and NAR and others named in the case itself, the case, as I said, went to trial in October of 2023. The jury found for the plaintiffs and against NAR and the remaining real estate agencies. And the jury verdict was $1.8 billion. And if you want to know why NAR settled this particular case, it is because under our antitrust laws, the judge could and can still, until this case is fully resolved, provide treble damages. That's 3 times the $1.8 billion. And so that would come to $5.4 billion if the case proceeded. NAR and the 2 remaining brokerage companies obviously settled the case post-trial, and NAR agreed to pay $418 million, and the 2 other brokerage companies settled for a combined $320 million. So the total settlement value in this case for everyone was $876.5 million. There is no one left to appeal the jury decision. All of the defendants resolved this particular case, so none of them can come back and appeal this. But because this is a class action lawsuit, you need to jump through certain hoops and procedures till you reach a final approval. The settlement itself has already reached preliminary approval, meaning the court says, okay, the settlement looks good, I'm going to enforce it, but first we have to send out notice to all of the class members, and they have to have an opportunity to object to that. Once that is done, the case gets set for final approval. The final approval hearing in this particular matter is November of 2024. So, who's covered by this particular settlement? The NAR settlement is global. It's a nationwide settlement, and it releases and covers NAR, its state and local realtor organizations, the MLSs that are owned or operated by NAR and its affiliates. Other MLSs can obviously opt into the settlement, and there is a formula for them in terms of paying what damages they would otherwise pay. The settlement also covers brokerages that did less than $2 billion in residential transactions in 2022. Very large brokerages are not covered by the settlement, but again, many of them have entered into settlements in other cases, and others have the ability to opt into this one as well. So, what did NAR agree to? What are the changes that we have that may concern us? NAR agreed first that the changes that will take place even before final release of this case, final settlement of this case. So, real estate agents, real estate broker companies must be fully compliant and fully implement the changes by September 16th, 2024, if they want to be covered by the release that we have here. Changes to the NAR practices. What are those particular changes? Seller agents in the future that's covered by this particular lawsuit will not be able to require or offer compensation for buyer's agents they won't be able to require be required to offer compensation for sellers' agents. No one will be able to require that any longer. MLS property listings in the future will not have any information about agent compensation. And the settlement specifically provides that these MLSs cannot create some similar mechanism or system outside of the MLS itself to make compensation offers. Sellers can still offer seller credits to buyers, and theoretically, some of that seller credit may get used to cover some commissions. But that's a longer issue and an issue to be resolved with investors in mortgage loans as well. Sellers can still, by the way, outside of the MLS, offer buyer agents compensation, but it's got to be done voluntarily outside of the MLS. And the key term over there is, in fact, it has to be done voluntarily. One of the most important pieces, because this is the piece that enacts a real change to the manner in which business has been done for quite some time now. And that is that buyer agents have to enter into a written buyer-broker representation agreement with the prospective buyer before they tour any houses. So today, as a buyer agent, you may get a phone call from a consumer that says, hey, I'm looking at this neighborhood, or I want to see this particular house, and maybe you can show me some other houses as well. And you'll go pick them up and jump in the car, and typically there isn't much of a discussion about what your if any, about what your compensation is going to be. That is going to stop, because before you go pick them up, before you tour houses, before you go around and look at places that are for sale, you have to have a written buyer-broker representation agreement, and it's got to be signed. And the compensation that you're asking for as a buyer agent, okay, has to be specified in the agreement. It can't be open-ended. So right up top at the beginning of the relationship between the buyer agent and the prospective buyer, there has to be a determination as to what the buyer agent's compensation will be in this particular transaction. Realtors cannot represent, by the way, that there's no cost unless they're going to receive no compensation at all. That was a big issue in this particular case because the plaintiffs believed that, in fact, most consumers that hop in that car, view property with you, end up buying that home, getting your assistance and buying that home, don't really think much about who's paying the commission for you. Some think it's actually free. So you have to disclose in writing all compensation you're going to receive from any source in the transaction as well. And you have to disclose that agent compensation is negotiable and it's not set by law. So right up front, you're creating a platform in which a buyer agent has to set up some type of a negotiation. Or if you're not going to negotiate, simply tell the consumer, this is what my commission is, and you are, consumer, buyer, you are responsible for paying that particular commission. You could say that maybe the seller will agree to help you out or to pay it, but that will come at some later date. That is not at the time they enter into the agreement. And I'm sure you can see the implications of that. First-time home buyers and all home buyers, it's a different methodology. It's something that's going to make them stop and think a little bit, if nothing else, along those particular lines. Beyond this particular lawsuit, the Department of Justice has been involved in a number of different investigations of these practices and investigations of NAR. In fact, back in 2020, at the end of the Trump administration, the Department of Justice settled with NAR and just put minor changes into place. But as part of that particular settlement, they said that they can come back and revisit this issue again. When the Biden administration came in, the Department of Justice said, we are canceling that settlement, and we are, in fact, going to go ahead and continue on with our investigation. It might be that the settlement of this particular case, the Sitzer case, addresses all of DOJ's concerns on a going forward basis. The DOJ has not objected to this particular settlement yet. They have not come forward and entered into, or put in a statement of interest. This may well have satisfied the Department of Justice, but only time will tell. There are other lawsuits that are pending there, and it's interesting because the Department of Justice did put in a statement of interest in another case that was about to settle, and that's called the NOSELEC v. MLS PIN. It's in federal court in the District of Massachusetts itself. That particular case, their settlement said that you can, in fact, list your compensation and what the seller will pay in terms of buyer agent compensation, but that it was optional itself. The reason the Department of Justice put in their statement of interest is because they said, no way. It cannot be optional, and it cannot be on the MLS itself. So that's the NOSELAC case, and my guess is the ultimate resolution of that particular case is going to be going more along the lines of the Stitzer case. All right, so what are the impacts of this particular settlement? Well, the first impact to you and the first impact to your industry is really uncertainty. There's a lot of uncertainty there. In fact, that's why we're doing this particular webinar. These are changes to long-standing customary practices. And when that happens, it creates that uncertainty. What may come out of this? There may be a lack of uniformity in how buyer agents are compensated. And questions arise as to whether a new customary practice is going to develop. There may be more competition that comes around between buyer agents. Some buyer agents may want to just enter into agreements or may have to, based on their negotiation with the buyer, for lower commission amounts itself. And that creates competition amongst yourselves. There are issues about how the buyer ultimately will pay the commission if the seller ultimately doesn't pick it up. Now, the seller may well pick it up if you provide an offer that's a good offer, and as part of that offer, you ask to have that commission paid by the seller. That is completely legitimate. And if it's a decent offer, I mean, one can assume that in most cases, that seller is going to pick it up. But there's a lot of uncertainty. Uncertainty not just for the industry, but uncertainty for the consumer, for the buyer themselves as well. I wrote in here that it's unclear if buyers will be allowed to finance their commission payments, but it's becoming more clear from Fannie Mae, Freddie Mac, FHA, that those payments are no longer going to be able to be financed. Effectively, today they're financed because really those payments are coming out by the seller, but they're coming out of the sales price of the home itself. So there are a number of issues and a number of things to consider. One thing that clearly is going to impact the manner in which you do business is your negotiation skills. You're winning that consumer up front. The question, the point of the matter is buyer agents, and we all know that. I'm sure we have a number of buyer agents that are listening in on this particular webinar right now. You provide an incredibly important part to this particular transaction. You are extremely important to the consumer, to the buyer. But now you've got to convince the buyer of that, because you're going to have a contract and you're going to have the buyer say, yes, I will agree to pay you X amount. And not only that, when you do that particular contract, it may be difficult for the buyer to walk away from that. It will be difficult based on the time frame that you put within that contract itself. There are a number of other issues and considerations here. Are there going to be others that are going to try to jump into this process? Are there going to be lawyers or accountants or financial advisors that say to consumers, you know what, I can do what that buyer agent does. Let me help you up front. I'll walk you through the process itself. Little cottage industries may in fact set up along those particular lines. One never knows about those things. Again, there's going to be potentially pressure, at least this is what plaintiffs are hoping for, and this is what the Department of Justice is hoping for. They're hoping for downward pressure on commission amounts because they're hoping that this will spark discussions, number one, with the buyer, where buyer makes his free choice itself, and number two, competition among agents along those particular lines. The question that's unresolved, and I'm not sure anyone's going to resolve this question today, is the significant changes that are going to take place. Will they only be operational? In other words, will it only deal with the fact that you have to have a written agreement with your buyer and you can get that written agreement? And ultimately, based on offers made, sellers will continue to cover that cost? Or will it be both operational and financial? And the truth of the matter is, only time will tell. Liliana, let me turn it back to you in the group.
Great, thank you, Mitch. That was awesome. Christy, what are you seeing in your conversations with other realtors, in your brokerage? Can you share a little bit about the impact that this is already having?
Sure. So when this was announced by NAR, it was March 15th of this year. And for that first 2 weeks, I feel like everybody lost their religion. They're going, we're going to all file bankruptcy. And then things started settling down. Tennessee, I know we have people watching from different states, but luckily Tennessee has always had a buyer's rep agreement, and you have to get that signed to work with the buyer. Now, do people do that at their first meeting? Not often. You have that time frame where you have to build trust with your client before they're going to want to work with you. So I think some things that will come out of this are showing agreements that maybe, okay, I'll show you 3 houses. If we like each other, let's proceed into a buyer's representation agreement. And let me explain what that looks like and how I can help you. So luckily we've been given time from NAR to figure out how these conversations are going to happen.
Yeah.
I know on listing appointments I've gone on, my agents have gone on, we've had sellers already say, well, I don't have to offer a buyer's commission. And the answer to that is correct. You do not have to. But here's the reality. Right now it's still showing up on MLSs that you will offer a compensation. And I don't know many agents who shopped for their clients pre-settlement by commission. I was shocked when that became something because as a realtor, the good realtors anyways are working for their client. They want to get their client into a house and the house that works best for them, right? So you rarely looked at that, and there's always been that 1, 2, or 3% offered. It's always been negotiable. So now I think a lot like what Mitch said, sharpen your negotiation skills because you're going to primarily be negotiating that into the contract.
Do you think this is going to actually impact the sales prices? Will you see a change in the market?
I don't think commissions ever dictated the market. Market value, the trends going on. So if there was going to have this settlement ever come to place, thank God it's 2024, when interest rates are over 7%, when inventory is rising, and when so many buyers have stepped to the sideline. Because sellers are recognizing they need to cast a wide net to capture the limited buyer pool that's out there. Had this happened in 2020, 21, 22, I think it's a very different conversation. But right now, I feel like the good agents are worth their weight in gold and will be able to help their sellers understand what a buyer agent does and that they need to offer some sort of compensation.
Yeah.
Right? And the good buyer's agent will do the same. They'll be able to articulate their value of, hey, some sellers will be offering it, some sellers won't. I'm here to get paid X, and I will negotiate as hard as I can for you to get that X.
Great.
Yeah. The interesting thing about real estate, I always tell my agents, there's a very low barrier to entry, but a high barrier to success.
Right.
So you really have to work hard at getting good at what you do and affiliating yourself with a good pool of lenders, other agents to work together so you're always sharpening your skills.
Yeah, I mean, there is so much data out there available, and a lot of buyers think, I'll just go find my house, and what value is this buyer's agent really going to provide to me?
Right.
So Mitch, and you are absolutely correct. You're going to have to say, these are the things I provide for you.
Right.
Knowing the values, knowing how to tell you what your offer should be. And then all the follow-up stuff that you do, all the inspections, setting up all that stuff.
Right.
Working with the lender. Communication is key.
I think the number one key there too is explaining to them by not using a buyer's agent how much more money that's going to cost them.
Yeah.
If they buy a home with all these pitfalls, or if they miss an inspection deadline, or if the house doesn't appraise, how do you negotiate that? Sure. Or if there's a glitch in the financing, how do we work around that? You know, you really, especially the first time buyers, and that's what kills me, is that it's the first time buyers who will be impacted the most, I think, who don't have any extra money laying around, and that first time seller, woohoo, I don't understand the value of an agent either.
Sure,
so yeah, but the great thing about real estate and the market and realtors and experienced lenders is we're super resilient, and the market always finds a way, and it will work for the consumer.
Right.
And I think this time next year, it's a whole different conversation.
What do you think about the impact on actual amount of realtors? Like, I know a lot of people do it part-time.
Right.
I'll just do it on the weekends. Do you think that's going to narrow and be more of a specialized, you can't just have it as a part-time job?
For sure. Time will tell on that. This year, NAR released a study that in 2023, 49% of all realtors sold less than 2 homes. Wow. So people are thinking, oh, those folks will get out of the business. Those folks have always been in the business because they're trying to pick up their cousin's house or their brother-in-law's house, or I'm going to sell my own house this year. I think who gets impacted, sadly, is that agent who is selling 4 to 8 houses a year, making, 60, 75, 80,000 a year. And if that gets cut in half, that agent is going to struggle to continue to work, because selling 8 homes a year is a full-time job. Right. And that's where I think we're going to lose potentially some agents.
Okay.
Yeah.
Great. And then from a lender perspective, Kevin, I know that Fannie and Freddie, if they've talked about the interested party contributions. Is there anything else you're hearing from any of the agencies about the NAR settlement?
Yeah, it's interesting. Just like Christy was saying, we encountered something like this in 2008 with Dodd-Frank. It changed our world. And so for all the realtors out there, we are sympathetic for you, and we understand. But the good news is it's going to be okay.
Yeah.
We're
going to figure it out.
It's going to be all right.
It's weird how we figure it out. Yeah.
And like you said, we're resilient, in the real estate market. And you've got some really brilliant people that are hard driving and hardworking and that are working on all this. But as far as that impact, we're already seeing. I was just talking to a loan officer this morning. They got a contract where the buyer is paying the commission outside of the seller. The seller is not providing it, and they agreed to do it. So I think, like Christy said, is going to continue to be showing that value more. And as lenders, we want to be part of that. So we're on the team with the realtor. You have a good lender, you're on the team with them, adding value to that relationship.
Right.
And so on the financing part, that's going to be interesting to see how that works. Because, you're going to also, if it's allowed, if it's customary in the area, right? Which it is right now, customary. So it's up to who's going to interpret if it's customary in the area.
That's exactly right.
So if it's customary in the area that the seller typically provides, commission for the buyer, then it's going to be allowed by Fannie and Freddie, and I heard VA as well, and FHA and HUD. And then you come into the play of appraisal, right? So if you're raising the price a little bit to pay the commission, then it still has to appraise, right? And then you're going to affect those first-time buyers as well. So it's going to take some work on everyone's part in the beginning to set the expectations, right? Say, hey, here are the expectations that you can expect. You know, are you paying, sort of ask, are you planning on paying for the buyer's commission no matter what
Right.
house you find? If you are, great. As a lender, we have to verify, where is that money?
Right.
Right?
Right.
Just like we verify everything else, right? And because that's part of the transaction. No, you're not. Okay. Well, have you talked to your agent about that? Right? And as a team, we as a team come in with the best plan of attack and the best strategy to go out and look for homes before we go out and look for homes, right? So I would urge all of you to do that before you go out looking at houses and someone gets excited and wants to write a contract, then already have a plan.
Right.
So I
Yep.
think it's going to take that.
That's very interesting. In the certified home buyer process that we do, which is a
Yep.
pre-approval process that we have that is fully underwritten and actually comes with a seller guarantee, we have to kind of play both scenarios. What if you find one where the seller is going to pay it? What if they don't? And we're going to have to take that into account when we're building it before you even start looking for
That's
a
right.
home. So
That's right.
a really good point.
We got to have a plan, and if you're not getting the money and you find the house that you love and you have to have, which we have happen all the time, and guess what? Seller's not paying the commission. Now what do I do? Okay, do you have someone else that can help you? Right? We can still use gift funds, right? So, do you have some gift funds? Let's have that conversation before you go out looking.
That's right.
Because people are going to get emotional when they find that home, and they're going to want to write that contract, and they're not going to have a plan. If they don't have a plan, then it's going to be tougher.
Right. And I think on the realtor side right now too, so much misinformation or inaccurate information has been thrown out from the media. And so we're having to make sure everyone is singing from the same hymnal to speak the truth of what we do, how commissions are paid. Not having compensation in the MLS isn't going to miraculously cause prices to drop 3%.
Right.
When the Wall Street Journal is telling us that prices are going to come down significantly, I'm like, the market determines that. It's not commissions. The commissions have been around since MLSs were invented in 1921. This has been over 100 years that this system has worked.
Yeah.
And so the market is what the market is. It's not commissions.
How many legally binding paragraphs is in a contract right now?
27 maybe?
Right. So I mean, if it were me and I were heading into buying the largest transaction I'd ever probably do in my lifetime, $500,000, right? Around our area, that's the average home price, right? There's no way I would enter into something like that unrepresented, right? And so on the lender side, I prefer greatly that they're working with a buyer's agent.
Right.
Because then those questions come to me if they're not. And I've had to deal with that, and I say, hey, look, I'm not licensed. I can't really help you with that part. This is what the buyer's agent does for you, So I do believe that it's going to be, like you said, Christy, it's basically just education. Educating the public, right? Because there's a narrative that has been said, now there's a different narrative.
Right.
So it's just changing the narrative back out there to say, hey, look, the buyer's agents are definitely worth every dime you pay for them. They're going to work really hard for you. I had a flyer last night my wife showed me and said, this guy's really working. It was a buyer's agent going around to all the homes in our neighborhood because a buyer from California wanted to move into our neighborhood, right? And saying, hey, if you're looking, give me a call.
Yeah.
That's a form of the way that a buyer's agent is helping the buyer.
Right. In so many
So-
more ways. I mean, I'm sorry, Mitch.
It is an educational process. You're absolutely right, but it's a tough educational process. It has to come from the industry. It has to come from companies, but it also is pretty much in the lap of the buyer agents. The issue that you're going to have, you're talking about how you're going to handle the transaction when the seller says no. The seller says, I am not going to pay that particular commission. That conversation has to be handled up front between the buyer agents and the buyer before they ever enter into agreements. Because the manner in which this, the settlement structures these arrangements there's going to be a binding agreement And the binding agreement is going to say, for example, buyer, will pay you, agent, 3%. And that's a legal binding agreement itself. And buyers are going to be very scared up front. Okay. When this first gets implemented, it's important that the industry and the individuals in this industry be on top of it from day one. Because when you first go to that buyer and you say you need to sign this contract and it's binding you to 3%, okay?
Or the negotiated amount. Let's be clear. That's a negotiated amount.
Yeah, or whatever. Whatever the negotiated amount is. But I'm just saying, if you were going to go and say this is my amount, yeah, absolutely, it's a negotiated amount. That's absolutely right. But that buyer is going to sit there, look at its numbers, and say, "Wow, can I really afford this? What's going to happen if I'm stuck paying this particular commission? What's that otherwise going to do to me?" And then you have to have a conversation with them about the negotiations that they can have with the seller. Okay. And with the seller, covering that particular amount for them. But they still need to know and understand that they're entering into this binding agreement. And that's going to scare a lot of people up front. That's going to scare a lot of people right up front when they first hear that particular news. So we have to find a way of explaining it to them where they're not as scared, where they say, okay, I understand what's going to happen here. In terms of, in terms of financing, Fannie and Freddie and others, they're not going to let them finance this. I think there are organizations that have talked to them about it, and FHA as well. And I don't think they're going to allow financing of the commission. What they did say they will allow is they will not treat the seller's payment of, a buyer's commission as an interested party contribution. So, interested party contributions, investors and agencies put caps on how much a seller can contribute to help the consumer out. This will not be a part of that cap. So this will be on top of whatever other concessions or contributions the seller wants to make. So that's good. That's fine. But my point is, there's still a level of uncertainty right up front when you go to the buyer, the prospective buyer, and he has to sign something binding himself to pay the commission out of his own pocket. And there's going to be a little bit of uncertainty over there. And the industry has to find a way to either, number one, help the buyer understand their own numbers and that it might be affordable. And number two, help the buyer understand that part of that, because I think this is absolutely true, is going to be a function of your negotiations with the seller. No different than when you negotiate to buy the house, you're going to put that in the negotiations as well. And if the deal is something that the seller wants to do, they're probably going to be okay. But I can see buyers right up front, taking their time, either backing away or sitting back and thinking really hard about it before they enter into a commitment itself that is for a significant amount of money, whatever that percentage might be.
Yep. What do you say we turn to some questions? Do we have some questions from the chat?
We do. Our first question is, do you all think the NAR and local associations will be providing an updated buyer representation agreement and updated broker comp agreement?
Yes, so in Tennessee, that's already underway. Our Tennessee Association of Realtors are working on those new forms. So we expect those within the next month.
All right, our second question is, if we contact the listing agents and ask if any compensation is going to be made to the buyer's agent, how will we confirm that amount? Can they change their mind after we write the offer? Is there any way to confirm this?
A good friend of mine wrote a book called Buyers Are Liars and Sellers Are Too. So until it is in writing and accepted by both parties, you are hoping that they are going to stay true to their word. But that's going to be the number one thing, is communication between agents and talking with each other about, hey, my seller's willing to do this, mine isn't, but how can we still work together? The cooperation doesn't go away. We just have to figure out that compensation piece.
Great. Okay, our next question is, was the MLS determined to be an unfair trade practice held exclusively for realtors? Do they have to make the MLS available to non-realtors now?
So great question. All these questions are amazing. It probably depends on how your MLS is owned. So in Middle Tennessee, it is owned by the realtor associations, right? We've got, I think, 7 realtor associations that are the stockholders there, or shareholders. So you did have to be a realtor member. It's my understanding that that will change. So there's a realtor and there's a real estate licensee. A real estate licensee that becomes a member of NAR becomes a realtor. So that will open up to licensees who are non-realtor members.
That's correct. That's part of the settlement itself. That's correct.
What's that, Mitch?
I said that's part of the settlement. You're absolutely right.
All right.
Anything else?
No, our next question is, will buyers be permitted to finance buyer agent fees if sellers don't agree to offer to pay buyers or the selling agent?
Yeah, I think Mitch was speaking to that point earlier,
Yeah.
that we don't believe that the agencies, but they haven't clearly indicated that, correct, Mitch? But that's where we think they're going.
I mean, they haven't come out with a statement that says no, but they have pretty much implied that that's the case. And that's why that's why at the same time they came out and said, okay, we will not treat that amount if the seller pays it as an interested party contribution.
All right, our next question is, do we know what's going to happen when dealing with VA and veterans?
Does anyone have any insights on VA?
Well, the VA rule that in fact a veteran cannot pay a real estate broker fee. So this obviously has an impact on VA loans itself. I think the VA is looking very hard at this particular issue and thinking about whether or not they're going to open that up as a result of this particular ruling, but they haven't done so yet. Today, this would not work because if it's a VA loan, the VA loan program does not allow the veteran to make payments. So they wouldn't be able to enter into the agreement and legally bind themselves to pay that commission.
All right, Mitch, this is a question for you. It says, am I correct in understanding that with Fannie and other institutions will allow the buyers to receive 3% seller concessions and additional concessions to cover the BA fee? I'm just not familiar with the terminology you're using.
So that's the same issue that I spoke to before when I talked about interested party contributions. You are correct. Fannie and Freddie and the agencies will allow the seller to pay whatever the fee, whatever the commission is. They will allow that to happen, and they will not treat it as your typical seller contribution. So the caps and limits they otherwise have on how much a seller can contribute on the consumer's behalf do not include the payment for the commissions. This is over and above it, and they'll be able to do that, yes.
All right, those are all the questions I have for us today.
Oh, good. Well, thank you so much for joining us today, and thank you to our panel. Thank you for watching. We hope you've learned a lot today about the NAR settlement. We'll keep you updated as we learn more in the coming months. And don't forget to follow Churchill Mortgage on Instagram, YouTube, and Facebook. Thank you very much. Have a good afternoon.